Devani. It's count number 1, fraudulent disposition of mortgage goods contrary to section 291 as well to section 96 of the Penal Code, chapter 63 of the laws of Kenya. The particulars that on 5th day of September 2008 in Nairobi City County within the Republic of Kenya, being the managing director of Tycoon Yagnesh Limited, together with others not before this court, being the mortgagors of the volume of 19,186.130 cubic meters of AGO diesel, jointly and with intent to defraud the mortgagee, that is Emirates National Oil Company in Singapore Limited, disposed a volume of 13,054.850 cubic meters valued at USD amount of Kenya of 10 million 446.88.36 and Kenya shillings 32,046,783.66 of the said flow to Total Kenya Limited without the consent of the Emirates National Oil Company Singapore Limited, the mortgagee. Your response? Count number 2, fraudulent disposal of the mortgage goods contrary to section 291 as well as section 36 of the Penal Code, chapter 63 of the laws of Kenya. The particulars: on the 6th day of October 2008 in Nairobi City County, Republic of Kenya, being the managing director of Tycoon Petroleum Company, a duly incorporated limited company, respectively, together with others in court in case number 18 of 2009, and being the mortgagors of the volume of 4,261.203 cubic meters of Jet 1 A1, jointly and with intent to defraud the mortgagee, that is the Emirates National Oil Company of Singapore, disposed a volume of 675,592 cubic meters valued at USD 550,020 of the fuel to Total Kenya Limited without consent of the Emirates National Oil, which is the mortgagee. Count number 3, conspiracy to defraud contrary to section 317 of the Penal Code, chapter 63 of the Kenya law. Particulars: on unknown dates between 23rd Republic of Kenya, being the managing director of Tycoon Petroleum Company, and a duly incorporated limited company, respectively with others with not before ACC 18 of 2009, conspired to defraud Kenyan Shell Limited USD 2,246,491.34 and Kenya shillings 7,059,201.59 by purporting to that the Tycoon Company Limited had a volume of 4,449.50 liters of diesel AGO held by the Kenya Pipeline Company at the Kipevu oil storage facility was available for sale. Your response?
Not guilty.
Count number 4, conspiracy to defraud contrary to section 317 of the Penal Code, chapter 63 of the Kenyan law, the laws of Kenya, Particulars: on unknown dates between 27th day of November and 30th November. Particulars: on unknown dates between November 7th of 2008 and December 10th of 2008 in Nairobi City County within the Republic of Kenya, being the managing director of Tycoon Company Limited, and others in ACC 18 of 2009, conspired to defraud Emirates National Oil Company 6.431 metric tons, which is in bracket 19,186.137 cubic meters of diesel HGO shipped via LP Summit Europe, valued at USD 473,672 by issuing a false invoice of Tycoon Petroleum Company Limited and Emirates National Oil Company, which is a private limited. Your response?
No.
Count number 10, conspiracy to defraud contrary to section 317 of the Penal Code, chapter 63 of the laws of Kenya. JB obtained a sum of USD 1,040,000 from Petro Kenya Limited by falsely pretending that the Tycoon Petroleum Company Limited had an aggregate volume of 2,000 metric tons, which is 2,360 cubic meters of diesel HGO held by the Kenya Pipeline Company at the Kipevu Oil Storage Facility for sale. Your response?
Not minimum. Is that the fact is a key person and all available offences, and we request that the accused be released on favorable bail or bond terms under Article 49, Sub-Article 1H of the Constitution of the Constitution then, which ensures that the accused persons enjoys maximum enjoyment of rights that he is entitled to by the supreme law of this country. Your Honor, when the accused in number 18 of 209 and also in E072 of 2024, which are basically the same charges that have been preferred here, or similar charges, all the accused.
Just a moment.
Criminal jurisdiction was 1 million shillings. And the prosecution in E072 then of 2024 did not oppose the terms that had been requested for, because they had been given in in number 18 of 2009. Your Honor, the circumstances, the documentation, the prosecution will be relying upon in the present case is similar to the documentation and evidence that they will be relying in E072 of 2024, now that number 18 of 2009 has been withdrawn against this person. Circumstances under which our client found himself, and the reasons, yes, and the reasons why he was in the UK.
Just a moment, because
okay. Or rather that we have, why we consider not a flight risk at all.
Why the first accused was in the UK?
Yes, exactly. When we travel to the UK, there's no indication from this affidavit that any charges had been preferred against him, and he was taken off as a result of any warrants or any indication that he was going to be charged. While it's at the UK, the charges then in number 18 were preferred, and extradition proceedings were initiated by the Kenya government to bring him back. As it were, our client challenged the extradition proceedings in the UK in court proceedings that the prosecution as a next to the application. Your Honor, challenging extradition proceedings is a lawful judicial process, and our client was engaged in that lawful judicial process as provided for by the law. He was not refusing to come.